Yeah, good afternoon, everyone. I, Sneha, on behalf of NEN and Vadhwani Foundation, would like to invite you all for this webinar and also introduce our expert, Mr. Anoop Kurup. Mr. Anoop Kurup, Director of Inolyst, has extensive years of experience in the intellectual property domain and has worked with researchers, patent attorneys, and business leaders worldwide in technology evolution assessment, IP commercialization cases, and patent design around assignments. Amongst his accolades, he is a certified TRIZ consulting, Lean Six Sigma, and one Hague awarded patent information specialist. He also has a patent application to his name. Before I hand over the floor to Mr. Anoop, here are a few reminders for the audience. You will all be on mute. You may ask questions by typing in the panel provided. Over to you, Anoop. Anoop?
Yes, I am here.
Yeah, you can start with the session.
Sure, thank you. Thank you for the introduction, Sneha. Hello everybody, I'm Anoop, and today we'll be just going through a few points on how a product company can create an IP strategy for their products. We'll be briefly running through the difference between intellectual property and intellectual property rights, how to form an IP strategy from your product strategy. I'll give you a couple of examples of the so-called IP strategy based on some famous products. And finally, I'll introduce a small service that we provide called IP Discovery. The session will be divided into 3 parts. Each part will be 15 minutes long, and you will have an opportunity to ask questions after each part. I'll cue you guys in with a slide stating Q&A. So you can ask questions for that particular session, that particular part, at your discretion. At the end of the session, we are also available to answer any other questions that you may have. You can write directly to me, or you can write into Sneha, and we will try and answer as many questions as possible. Why do people get into business? Why have a business at all? Peter Drucker said that a business exists to create a customer. Now, a customer is any person who needs your services or your product. So what you need to do is add value to a customer. Therefore, if your business exists to create a customer, anything creative that your business does to create and keep the customer belongs to you, and it's your intellectual property. After all, it's a creation of your mind. So I kind of define intellectual property very broadly when it comes to the context of a business. The legal definition of intellectual property varies from person to person, but there is general consensus that intellectual property is equivalent to intellectual property rights. They are nothing but legal instruments provided by the law of each country. So you have different IP laws for India, and you have different set of IP laws for US, Europe, etc. And the laws govern what type of rights you will get for your intangible ideas or assets or creative art or work. But in the context of a business, intellectual property rights should protect your creative endeavors to acquire and keep customers with you. It's very important to differentiate the general definition of intellectual property rights and the one which is associated to a business. Intellectual property rights per se do not change for a business or for an individual, but how you look on it and how you utilize intellectual property rights vary a lot. Let me give you a few examples of intellectual property rights so that it sets the base for for the discussion. There are many types of intellectual property rights as per law. In India, we have at least 10 or 11 of them, for which we have laws, including designs, trademarks, geographical indicators. You might have heard of Dashanti, for example, or Tirupati. These are all geographically indicated because they are belong to a particular geography or a particular, let's say, set of people who use them. Then there's copyrights, patents, trademarks, which are generally well known. There's also something interesting called a semiconductor chipset design. The topographical structure of a semiconductor chip is actually protectable by intellectual property. Of course, trade secrets is something which you keep secret. There's no right given to you because if it's a secret, it's a secret. Nobody else in the world should know about it. So Coca-Cola's formula is supposed to be a very well-kept trade secret. So is KFC's formula. Let's take a look at one of those famous designs, which is well known to pretty much everybody who drinks a soft drink. Designed and granted a right somewhere in 1915, almost a century ago. This bottle is synonymous with Coca-Cola. Any other company trying to utilize this design would actually be trying to defraud the public in one sense, because it's famous and it's associated with one particular company. So industrial designs are all about the look, ornamental look, and ornamental aspect of product. This is important because we'll come to a case study or an example later on where this concept is being utilized. Trademarks, another well-known aspect of intellectual property right. All of you who are listening into this webinar probably work for a company, and the company has a name, and the company's name is also probably associated with the logo. Now that logo belongs to your company, and people recognize your company with that logo. Therefore, that becomes the intellectual property of your company, and it is protectable by something called trademark. Even certain products that your company produces. For example, I'll give you an example of a phone. Right? There's something called a Samsung Galaxy 3, for example. Right? Samsung Galaxy 3, the Galaxy 3 part is associated with the phone produced by Samsung. So somebody else trying to use that name, Galaxy 3 for the phone, would probably is trying to defraud the public. Now, it's very important to understand the difference between a trademark, as utilized by a company for a product, etc., and the difference between somebody trying to just use colors or words, to launch a couple of instances of a product. Trademark should be publicly identifiable. People should be able to recognize your product with the trademark and the trade name. So, for example, iPhone or Coca-Cola or Intel, IBM, all these are trademarks that are well recognized by public. Let me give you an example. In India, there was a landmark case wherein somebody was selling chocolates in a purple color wrapper. Now, a purple color wrapper is well associated with Cadbury chocolates. The judgment was this person who was trying to sell chocolates had to stop selling them because Cadbury had sued him and said, he's infringing on their trademark. What the court determined is, although it's a color and it's a color of a wrapper, but it's very well associated with the company and the public perceives it to be the company's product. Therefore, it was important that the person who was trying to sell chocolates in purple wrapper does not do it. Another very, very important intellectual property right that a company can get is patents. Patents are tough to get, it's very stringent the way patents are scrutinized and granted. So the threshold is higher, but the benefits are also probably a little bit higher than other types of intellectual property, because patents are all about products, relevant to products and inventions that go into products. And they give you 20 years from the date of filing to pretty much block others from producing what you have a right to, which in one essence means you can block off your competition from entering the market. Of course, the threshold for getting a patent is higher. Whatever you try to patent should be technical in nature, should be industrially useful, should be new in the world, as in the improvement or the invention that you're introducing, or an improvement to an existing invention that you're introducing should be new in the entire world, not just in the country that you're applying. For example, if you're applying in India, the scrutiny is not just based inside India, but it's the scrutiny of your invention will be done through the world, which means that at the end of the day, your invention has to have some new element and has to be differentiated from anything that's publicly available in the entire world. And there's a third aspect, that it should not be a very trivial thing. Like if two people sit together and dream it up on a paper napkin, probably it's very obvious that such an invention can be, or such a technical advancement can be made by anybody who knows about the system. An invention should have some amount of experimentation, some amount of work that takes to bring it to life. So it should not be obvious, in other words. Invention should not be like mixing sugar and water gives you sugar water. That's well known, that's obvious to everybody. So it should not be as trivial as that. That's all about patents. So these three different concepts, trademarks, industrial designs, and patents, are something that I will be touching upon in the next section. So I'll just pause here for some time and enter a Q&A session. All of you have 5 minutes to ask all the questions you want to ask regarding the previous few slides, and I'll be happy to answer them.
Kindly post in if you have any more questions. There's one question from Tejasvi. He asks, if you have an idea and it's patented, is it advisable to buy in startup stage, that is the early stage?
Hello? I'm sorry, yes, Neha, I'm sorry, but the question is not very clear. By what? By the patent?
Okay, I'll just ask him. Okay, there's another question from Dharmesh. He says, what sort of IP protection can e-learning modules get?
See, e-learning modules can be protected by copyrights mainly. If you are talking about the software part itself, then the patenting can be an option depending on the country of business. But if you are talking about the syllabus and the content of the modules themselves, then that's probably protectable by copyright and not much else.
Okay, our next question is from Stephen. He asks, what is the cost of patent in India?
The cost of applying for a patent, the government fees is about 4,000 rupees for a company. That is for a company, and for an individual it's about 1,000 rupees. The entire process should cost you something about 25 to 30,000 rupees over a period of 4 to 5 years. But the charges for somebody's, a lawyer's charges would be different, and it differs from attorney to attorney, or firm to firm, or consultant to consultant. That could vary anywhere between 50,000 to a lakh or upwards of that.
So this question is from Tejasvi. He says, if the feature in my app is patented, is it advisable to buy that feature or to redesign or reprogram my app feature?
Good question, Tejasvi. The answer is not very straightforward. It depends kind of an answer. It depends on how much money you have and how much money the patentee is asking you. If somebody is patented a feature in your app and you think there's a strong possibility that they'll take you to court over that, well, it's better to talk to them and figure out what the implications are. And if the licensing piece is very large, then it's better to design around it and maybe drop the feature altogether. There's another factor. If you're worried that somebody's got a patent in the US for a feature in the app, of your app, and you're worried they will sue you, then I think that is probably a little bit paranoid, because a patent in the US is only applicable in the US. So if your application or your app is not going to be launched in the US, then you don't have to worry much. On the other hand, if it is going to be big, US is going to be a big market for you, and this feature is very, very critical to your app, then I would suggest please go ahead and talk to the patent. Hope that answers your question.
Yeah, and there's another question from Stephen. He says, how long is the patent valid in India?
Patent is valid from 20 years from the date of filing, once it is granted.
Our last question for this session is, what is the life of a copyright, a patent and a trademark? Is there any expiry date?
All of them have expiry dates. Patents only last for 20 years from the date of filing. After that, you cannot renew them. Trademarks last from, varies from country to country. I'm telling you about India. Trademarks last about 10 years, but you can renew them. So, they can last forever in that sense. A copyright, on the other hand, is a little more tricky, because they can have an expiry date of anywhere between 70 years to 150 years. So they're very, very long-term copyrights. The law is also undergoing certain changes. So just, as a ballpark, take it as about 100 to 150 years.
So we'll have.
I hope that answers your question.
Yeah. So we'll have the second part of this webinar starting. The rest of the questions will be dealt after the second part of the webinar is over. You can keep sending in your questions during the webinar. So Anoop, you can start the second part.
Sure. Thank you, Sarah. So let's talk about the main agenda of today's webinar, that is the strategy development piece itself. IP strategy development for products requires us to understand why products exist in the first place and what the USP of a product is. How do you go about doing that? Coming back to my favorite author, Peter Drucker again, he said business exists to create a customer. So this is kind of tricky, right? How do you create a customer? You create a customer by delivering value to the customer, obviously. But who is the customer and what type of value are you going to deliver? That's why businesses are oriented around products or services. They usually are not oriented around customers. You don't say, I am going to serve the demography of 18 to 25-year-old male in southern India. That's not your business. Your business is probably selling vacuum cleaners, manufacturing and selling vacuum cleaners to households. Your businesses are usually oriented around a product or a service, or multiple products and services. And any person who buys your product or service is your customer. So your business is oriented around identifying a demographic or identifying a type of customer and satisfying their requirement or adding value to the customer. What is value? Value is again very, very subjective. Value is what a person perceives it to be. Something might be of great value to a person and of no value to another person. Depends on their requirement. Well, that's a philosophical discussion probably for another time, but let's just for the time being understand that you create a customer by delivering value. Since businesses are oriented around services and products, and this for product managers, product developers. I would also state that a product delivers value to a customer. Again, the how, what, and why of a product is important in this. For example, when you say a product delivers value to a customer, quite a few questions arise. What's the delivery mechanism when you say deliver? Where will it be delivered? When will it be delivered? How will it be? So the means or the distribution channels themselves are important. Thanks to e-commerce, you have a large distribution channel which is at the back end and customer-facing front ends. So another aspect is what value are you adding to the customer? When if you're adding value to a customer, then it's a product, or it's a type of product, or it's a feature, or it's a need that you're satisfying. What need is being satisfied, and why is your product superior to another product? That's also important. Then again, who is the customer? Right? As I stated before, businesses are usually oriented around products and services and not around customers. The products and services may be serving a particular customer case, customer type, but your business is usually not oriented around that. So again, these questions have been answered quite a few times, or there are many models that allow you to answer these questions, including Porter's 5 forces, business model templates, and value chain analysis, competitive assessments. Ever so many management models allow you to answer these questions. These questions form something called as business strategy or a product strategy. Now, why am I talking about a business strategy or a product strategy in the context of IP? Because ultimately, as we saw earlier, anything creative that a business does to keep a customer, create a customer and keep a customer, is the business's intellectual property. Therefore, a product that you manufacture automatically has a lot of creative input that the company puts in and contains a lot of your intellectual property, which is getting delivered to the customer. So your business strategy is based around how to develop and sell that product to the customer base, which means your intellectual property strategy should also be based around the product, the sales channel, the distribution channel, the value add of the product, and the customer base itself. Which means ultimately your intellectual property strategy should align with your business strategy and your product strategy. And the intellectual property strategy is nothing but a set of precautionary measures that you take so that your profit margins don't get killed all of a sudden one day by a new entrant or a substitute in the market. And so that you can keep the competition at bay for a certain period of time. So ultimately your intellectual property strategy has to align with your business strategy. If your business strategy is not clear, then your intellectual property strategy will not be clear. I'll give you one very good example of how to align a product strategy and intellectual property strategy to cover maximum ground and to gain maximum market share. Now, the best a man can get, most of you will identify with this tagline, this service line, and it belongs to Gillette, and it was in the context of a product called the Mac 3, Gillette Mac 3. Now I have a picture of the Mac 3 Turbo, which is the later version, right? If you see, this has many new things. This product has many new things about it which did not exist in the previous products. One of the biggest things you can see is that it has 3 blades. Okay, great. So what's the big deal about 3 blades? Right? Why have 3 blades? It has a lot of other features like a lubricating strip, a totally new design, a cartridge holder, ever so many things which are very unique about this product. Again, if you go back and ask this question in relation to Gillette Mach 3. A product delivers value to a customer. What type of delivery mechanism, what type of value, and who's the customer? If we were to analyze these questions with respect to Gillette Mach 3, what we realize is a Gillette Mach 3 delivers a smoother shape to a customer being men or women, depending on the type of product. The delivery mechanism itself is not very important here because ultimately the product is being delivered to the customer via regular sales channels, retail stores, supermarkets, etc. So any point, any place that you can buy your groceries from probably is a place you get, Mach 3 also. Having said that, let's see how does it look if you were to analyze it further. Gillette Mach 3 delivers smoother shape to a customer, right? So the smoother shape aspect is what is being saved, or what is the USP of the product. It is what is setting it apart from its competition. If that is the case, the smoother shape aspect is what sets it apart from its competing products. How do you safeguard that aspect? After all, it's a hard product. Smoother shape is being delivered by what? Is being delivered by 3 blades. The design, the way it is manufactured, the way it is coated, the lubricating strip, etc., etc., etc. So what did Gillette do in this case? What was their strategy to safeguard their product, their interest? It's very interesting. Gillette Mach 3 delivers smoother shape, so protect every single aspect that allows a customer to get smoother shape. Which also means that Gillette had to safeguard and protect every single aspect that allows them to build a product that delivers a smoother shape. So Gillette went with the strategy of applying 35 patents. 35 patents for a tiny little product. But they also have about 60 to 70% of the market in wet shaving razors because of this new product. That's what's so interesting about it. And what was this 35 patents about? I mean, it's actually such a small, tiny little product. Where do you get these 35 patents from? For what aspect? Everything. Gillette went ahead and protected aspects like coating process for the blades, cartridge loading system, high-speed photography techniques. Just imagine, if you want to test your product, how would you do it? In this case, the testing mechanism was to give the razor in somebody's hand and ask them to shave, right? But how do you monitor that? You had to develop a high-speed photography technique, mechanism, probably load a camera on top of the shaving set itself to monitor how it is going, how it is working. Even that process of testing was protected by Gillette. Why? Suppose somebody else wants to make this shaving blade. They want to test the blades. How will they do it? They will have to resort to some other method. Something which is probably not as effective, efficient, or not as cheap. They may have to resort to a costlier technique, which means a competitor's costs go up, which means Gillette has a higher profit margin because their costs are lower. Gillette went ahead and patented blade positioning. 3 blades, arrange them in any order. If the angle changes even by 0.05 degrees, you will shave off your skin, not the hair on the skin. The forming of the blades, these are thin blades, right? How do you form these blades? How do you attach them to the cartridge? The cartridge itself, the loading mechanism of the cartridge is very unique. You have a clip-on mechanism here. An indicator strip is available on top of the blade itself that tells you when the blade is going, it's getting blunt. And that also adds to lubrication while you're shaving. It's interesting that 35 patents were applied for such a small little product. where all it does is give you a smoother shape. But for Gillette, very important that they went ahead and protected the smoother shape, that experience that the customer gets. It was important for them to understand where the customer will get maximum value from their product, how the product is differentiated from competition, and how they can protect it. Gillette could have gone ahead and just launched the product in market, but within 2 days, another competitor would have copied it and launched the product. Interestingly, Wilkinson Sword, you might have heard that name. Wilkinson was acquired by Sheep. Sheep is a company which produces a blade called Quattro, which means 4. And they came out with that after Gillette came out with the Mac 3, and it has 4 blades. And Gillette took them to the court, saying that, hey, you are infringing my patents, and the battle was very lengthy. Gillette actually ultimately lost the battle. But because of the prolonged battle, what Gillette was able to do was gain and keep a market share of about 63% in the wet shaving industry. That's what is so powerful about their strategy. They have protected every single unique aspect of their product, not let anything be chance. They have even cross-linked the patents such that anybody trying to develop a product which is even remotely close will infringe on their rights, and they have a right to take that person to court. There is a redressal mechanism in place if somebody tries to steal their or copy their product. Something similar happened in the Samsung versus Apple case. I mean, the verdict is still out. It's all about designs. But same thing, at least Apple as a company had a redressal mechanism. They could take Samsung to the court and say, hey, you know what, these guys are my biggest competitor. They're eating into my market share. There's something I need to do about it. Can I stop them for some time? Or can I block the competition for some time? And that's what they're trying to do for quite a while. It's interesting how product companies think about differentiating their product from another product. In this scenario, Gillette's Mac 3 was totally developed in-house and manufactured in-house. They did not outsource anything. They did not in-source anything. Everything was developed by them. So all the intellectual property belonged to them, which means they could protect everything that they could think of. In this case, 35 different concepts. I think this will take a little bit more of explanation. So what I will do is I will go ahead into a Q&A session, and I want you guys to ask as many questions as possible for this. Sneha, please take over.
Sure, Anoop. Our first question is from Dharmesh. He asks, are copyrights renewable?
No copyrights are renewable.
The second question is from Sharad. He says, if you are manufacturing a product and get your product patented, and if somebody else is also manufacturing the same product, so can you sue them?
Yes, that's the whole idea, right? The whole idea is that if you have a product and you're manufacturing it and you get it patented, somebody else tries to manufacture the same product, you sue them. But I think we need to clarify here that if your product is under manufacture for quite a few years, then you can't get a patent on that because it's already in public for quite some time now. But what you can definitely do is try and protect unique parts of the product if at all some improvements were done for them. And I'll give you one example. For example, if two people are manufacturing safety pins, right? One cannot try to get a patent and sue another person. It may not happen because you will not get a patent at all. On the other hand, if it's a unique product and you apply for a patent, and later on somebody comes ahead and tries to copy it, then you can take it. I hope that answers the question.
Our next question is from Raman, and he says, which prototype design should I file first for IP? The best designed version, which may take time, or the first designed version, which is less finished?
Patents don't require you to actually prototype anything. It's a very interesting question, prototypes and patents. We have seen this question come many a times. Before applying for a patent, you need not prototype. When you are applying for a patent, what matters is that your idea can be reduced to practice on paper, at least. Theoretically, it should be strong, and it should be manufactured. But what happens is, many a times, people go ahead and prototype and wait for the final version. That's not true. That's not necessary either. Because patents are granted for strong concepts and solutions for problems, not your particular prototype. Because let me give you an example. If I were to patent, the first one to patent the ballpoint pen. I would not call it a ballpoint pen. I would probably say a writing instrument having spheroidal end. It's a spherical ball sitting at the end of the ballpoint or pen. That's it. One statement. A writing instrument having a spheroidal end. Right? Now, how I manufacture the ballpoint pen, how the ball is being placed inside the ballpoint pen, all that is secondary. I can have as many versions of my ballpoint pen as I want. But the concept there is that if I can make a writing instrument with a ball tip or not. So to get a patent, you need not make a prototype. You need not wait for the best prototype to come up with. What needs to be done is you apply for a patent as soon as you think the concept is something which is workable. I hope that answers the question.
Yeah, there's a question from Shivambika, and it says, do we have patents for artwork?
No, we don't have patents for artwork. We have copyrights for artwork.
Okay.
The only way to protect artwork would be using copyrights.
Okay. There's a question from Stephen. It says, if we create a product, how is the level of innovation looked up for patenting? Should it be a perfect innovation, or an incremental innovation can also be patented? And if the product is already invented by someone but not yet patented?
There are 2-3 different questions. One is, I don't think a level of innovation is something anybody assesses when they go for patent. What they tend to do is, as I said, patent officers scrutinize it primarily on 3 criteria. One is it industrially applicable? Second is it new in the world, if somebody else has done it already or not? And the third one is it a trivial thing? Is it obvious? Can some 2 things be combined to get your invention? If not, then yes, it might be granted. Now, when you ask me if somebody else is manufacturing, can you patent it? Probably not. If somebody else is manufacturing, it's publicly available, you cannot patent it. I said probably not because it's a tricky question to answer. What part of that product are you going to patent? Is it going to be a new thing? Is it going to be improvement on it? I don't know. If it's exactly something which exists in the market, you cannot get a patent on it. And as for the improvement versus a totally new thing, I can put it this way that 95% of the patents that are being applied for are just incremental improvements for existing inventions, For example, you can make a better earbud, or you can make a better speaker, and you can improve the efficiency of the engine by maybe 0.5%. The way you do it is what is patentable. I hope that answers the question.
So we'll start with the session, and whatever questions keep coming, we'll take it after the 3rd session.
Sure.
All right. So you can keep sending your questions. We'll start with the 3rd session, and after 3rd session, we'll take up your questions. Thank you.
Thanks, Neha. The last part of my session is another example. And this is a very, very famous one. Most people recognize with this product now. It's been almost 13 years that this product is in the market. It's the Apple's Ipod Classic. This came out in way back, somewhere in 2001 time. It changed the music industry. So I'm not going to talk about how the entire ecosystem of the product itself, which includes iTunes and the musicians and the music companies and all that. I'm just going to focus on this hardware, this particular piece. Now, why is this interesting? If you were to go to my previous slides and think about how to create an IP strategy for a product, the first thing you might think is, let's go ahead and apply for a few patents for this. But as I also said, your product has to be differentiated from the competition. And your product should have something unique about it. And those unique aspects are what you should try and patent. So in the case of an Apple iPod, now it's called iPod Classic, right? Apple iPod, what was unique about it? If you look inside the iPod Classic, there's nothing which actually Apple has created in one sense. The chipset belongs to somebody, the battery belongs to somebody, the hard disk belongs to Toshiba, Samsung has certain parts. I mean, each and every company which deals with electronics probably, provides a part to this product. So the parts themselves are not unique. Music player, MP3 players existed before the iPod came into picture, so the concept itself was not unique. Screens and the way music is selected was not unique. Storage mechanism and listening to music was not unique. So when none of these aspects were unique, what was so unique about this product? What was it that set it apart from the competition? What was different about it? There was only one aspect to this product that was different about, that set it apart from the entire competition, and that was its design. So iPod has undergone a lot of changes. Now it looks pretty much like the iPhone. But if you look at the classic product, it again underwent many changes over a period of time. And on the top, the various images that you see are all sketches taken from Apple's design patents. I had spoken about design patents a while ago. And all these design patents were applied for over a period of 4 or 5 years, and Apple tried to patent every single design that they came up with. And that is what was unique about this product, the design. People started identifying this product with the design of the product. Now if you see the bottom right hand side, there are many versions of this product being shown, and at this juncture, if you draw the symbol of a big rectangle, small rectangle, these circles, anybody can identify it to be an iPod Classic. It is well recognized by the public. So what's happened here? It's a very, very nice strategy, an interesting strategy that Apple applied for the design. Over a period of time, the design became so famous that it converted itself into a symbol. Now the symbol is so famous that it is a trademark. Anybody who draws the symbol symbolizes this particular product. So the product has gone to design, the design has gone to become a trademark. So if somebody were to make something for the iPod, all they have to do is put the symbol on top of the product and say, this is for an iPod. That's very, very interesting, because although the design patent will last only for 14 years, it will expire, but the trademark itself will last forever. This symbol will last forever. And people can recognize or identify this symbol to be synonymous with the product. And that is what Apple's entire strategy has been when it came to the iPod. And I think that is their strategy even with respect to most of their other products, because the differentiator is the look of the product, how the product looks, the design of the product. And that's what they're trying to protect. Because ultimately what's inside the product is probably being sourced from multiple places. There's another aspect to the Apple strategy which is probably not available publicly, or which is not very evident to people. Apple also manufactures very, very high-end products at probably affordable prices. Affordable in the sense that they are very, very costly if you were to manufacture 1 or 2 pieces of them. But they are able to manufacture products at cheap cost, sell them for premium prices, turn a profit, and these products are pretty cutting edge in terms of what they include inside. So how do you manage to make such a cutting edge product and still manage to turn a profit? The only way to do that is to have very, very good supply chain management, very, very good sourcing and logistics. And that is a secret sauce. That's where Apple probably succeeds when their competitors are not able to. Although the products can be copied, the supply chain and logistics are not easy to copy. So if you can keep your costs down, you can always make more profit, even if somebody else is going to copy your product. Now, keeping the cost down is something which Apple has managed to do beautifully over the past few years. And that's why they have probably 70–75% of the profit share of the entire smartphone market. They pretty much have the entire share of the music market now because of the ecosystem they have managed to create. That is the example which I wanted to give you, that a product need not be only protected with patents. What you need to protect is your product's USP, the product's unique features, the product's differentiator. You need to protect ultimately what's your own and what promotes the product, what allows you to create a product at a cheaper cost, sell it for a higher margin, the materials you use, the combination of materials you use, the processes you use to invent the product or create the product. All of it is protectable, but by different instruments of the law. Therefore, I'll leave you with this example. But this entire exercise seems very, very complex. If you were to think about it, you have to figure out what your product is, you have to analyze your competition, analyze their products, understand all over the world that has anybody else done it, and then come out with a strategy. Seems very tedious. It is actually very tedious and time consuming. That's why we also at Inolyst launched a small service called IP Discovery, which allows you to utilize our skill sets to come up with these answers. Under this service, we analyze the business models that exist for your competition, for your own business. We understand the competition's products, we understand how they manufacture, what they do, and we differentiate your product from theirs, and we ultimately create an IP strategy based on the markets you're going to approach, based on the competition, based on your future plans, and based on the law of individual countries. So I'll give you an example. If you are creating purely software products, it might be a better idea to go to the US and patent it if US is a big market for it. On the other hand, if you're going to sell software products only in India, it might not make sense to go ahead and put patents in the US because it's a costly affair and it is not going to serve your business at all. So IP Discovery is a service that we at Inolyst deliver to our customers for establishing good, strong IP strategies around their products and services. Thank you for your patience. Now I'm open to take any question you have. Sneha, please take it.
Yeah, our first question is from Dharmesh. He says, if I post some copyrighted digital content on the internet, what can I do to ensure that it is not used commercially by just about anybody else?
It's a good question. Now I'll give you an analogy. You can put a fence around your house, but that will not ensure that nobody jumps it. You will have to be vigilant about it. See, if you write a blog article or you put some lyrics online, right? Or let's say you write a blog and you put some very interesting analysis of something there. Somebody else copies it. You will have to be vigilant about it. You will have to put copyright notices. If you identify somebody has copied it, you will have to take them to court. You cannot prevent others from trying to steal things from you, but you can definitely have a redressal mechanism by which you can get some compensation, or you can stop others from stealing what is yours. Also, one important thing is that if you have put content online, and if it's copyrightable, and if you think it's very, very important, if it's a revenue stream for you, then it makes a lot of sense to register that at the Copyright Registry Office. We have that in India. It's fairly a very, very simple and a very, I would say, economical process. Once you do that, it allows, the government pretty much gives you a stamp saying that this so-and-so content belongs to you, so that when you go to a court or take somebody to court, sue somebody, you have a, let's say, a government certified document to say that something belongs to you, and that allows you to seek redressal for your, somebody is infringing your copyright. I hope that answers your question.
Question is from Dharmesh only. He says, is there any major patent known to be associated with digital content creation?
Pardon me, digital content what?
Is there any major patent known to be associated with digital content creation?
It depends. Digital content creation and management, there's something called as DRM, digital rights management, right? That allows you to move content around, or does not allow you to move content around. Digital content creation itself is a very broad term. It can refer to anything, including music, videos, blog articles, lyrics, anything, right? So pretty much every mechanism you use kind of covers it. If you're talking about, you have to be very, very specific. You have to be more specific about what type of digital content you're talking about.
Our next question is from Tej. He says, can I protect IP when I'm outsourcing my app development to a third party or a developer? If so, what points to consider?
Certainly you can. The concept is yours. The concept is not your app developers. See, for example, I'll give you the example of patents. Patents are granted to the person who came up with the idea or the concept, not to the person who tested or experimented or developed the idea. I'll give you an analogy in chemistry. In pharmaceuticals, for example, if I am the one who came up with the idea for a particular drug, let's say a molecule, a new type of drug, right, a new type of medicine, but somebody who's my associate or my junior goes into the lab and experiments, that is probably a tricky thing, but patent law is very, very clear, stating that I will be the one getting the patent and not my colleague or associate who went and did the experiment. It's not the developer who gets the patent, but the originator of the idea who gets the IP rights. So the precaution you can take is when you put together a contract agreement with your app developer, you can say that all IP will belong to you. So there is an IP clause in pretty much every contract, and here also in the contract you can have IP clause stating that all intellectual property will belong to you or your company. Sneha, next question.
Yeah, Anoop, I think that was the last question for the day. Okay, there's another question from Stephen. He says, if I create a product and have a first mover advantage, and in a short span, if someone else also created the same product as a competition, and if he has patented it, then will it stop me to further continue with my product?
Two issues there. One, if you have the first mover advantage, then how will the other person patent it? Right? Your product is already in the market. And the second issue is if somebody else is patented and you are not aware of it, they can definitely block you from producing or manufacturing your product. So the answer is yes to the second question. The first one, I'm not very sure. If you have a first mover advantage, how somebody will get a patent.
There's a question there's a question from Karthik. He says, is copyright or patent restricted to manufacturing segment alone?
No. Patents are not, none of the intellectual property rights are restricted to any particular segment. They are restricted to forms of creative endeavors. For example, if you if you have a particular new type of video, right, a documentary, that is copyrightable. A movie is copyrightable. Lyrics are copyrightable. The songs are. So is the dance. But if you were talking about a new invention, then it could be that the invention comes out of an industry, so probably, you know, it is patented by the industry. But that does not stop from individuals to go and patent anything they have invented. Very interestingly enough, in the US, most of the inventions were created by individuals at one point of time. Other questions?
Yeah, our next question is from Dharmesh. He says, is a patent or copyright or a trademark transferable or sellable? And how is the value gauged?
Yes, they just like any asset, any property that you have. Patents, trademarks are movable, sellable to another person, another entity. The valuation is very subjective in the sense that there are multiple models of evaluating the worth of a patent or a copyright or a trademark. But it depends on the asset under consideration. Just like a property, right? I mean, based on the location, there were so many other factors, the property is evaluated. Similarly, a patent is also evaluated based on a patent or trademark, or even a copyright is evaluated based on multiple parameters. There are good valuation methods available.
Our next question is from Nikesh. He says, if there is no possibility of having same website name, then why copyright for websites is required? And what is the approximate cost involved?
Same website name is okay, but the content on the website can be copied, right? You can have abcd.com and you can have abcdef.com, but both the websites can have the same content because one was copied from the other website. So the copyright is for the content, not for the name. The content, that is the write-up, the images, the placement of all those things, including how it looks. That's the copyright. And the cost of filing a copyright in India is, I think, is a 100 rupee form or something, plus the charge of the agent or the attorney whoever works with you. It should be pretty nominal. I think it should be below 4,000, 5,000 rupees that the entire thing should be done. Another question?
No, I think, Anoop, we are done with all the questions. If you have any more questions, maybe you can mail it to me or Anoop on the ID shown on your screen, and we'll see that you receive your answers. Okay.
Thank you, everyone. Thank you, Sneha, for hosting this session, and hope to speak to all of you soon again. Thank you.
Thank you so much, Anoop, for that interesting session. Thank you to all our attendees for participating in the webinar. We are glad that the questions are still coming, and so you can write to eclub@nenglobal.org. Please send in your feedbacks and suggestions. And if you found this session interesting, feel free to blog or post about it. The recorded version of the webinar will be available on our website by the end of this week. NEN Entrepreneur Support and Training is also conducting an IP workshop in New Delhi on protecting and managing intellectual property rights in your company on 16th of March. Registrations are still going on. Please look up our website for more details. Thank you once again and have a nice evening. Thank you.